I'd like to begin by thanking you for having me here to speak with you this morning. I'll give you a little bit of background about CAEPLA. CAEPLA is a non-profit, federally incorporated organization, and we have a board of directors, and they're all farmers and ranchers from across Canada. And I'm the founding CEO, and we were formed in the year 2000. So now I'd like to give you a little bit of background of where we came from and who I am. I was 2 years old when the first pipeline was put on my dad's property. And I grew up just outside the city of Sarnia, where pipelines from across Canada came into Ontario and then went on to Toronto and Montreal. So I've had Enbridge pipelines on my property my whole life. After growing up on my dad's farm, I bought my own farm, and it happened to have pipelines on it too. At the time, I didn't know any better. Being so young, I didn't know anything about pipelines, of course, in 1957 when the first pipeline came on my dad's farm. But at that time, the local government official came around and convinced my dad that it was in the public interest to build that pipeline. Moving into the future, in 1993, on my farm, Enbridge wanted to convert a pipeline from gas to oil, or no, from oil to gas. And the land agent came to my farm many times to get me to sign an easement agreement. At that time, you know, we had just come through a couple of world wars. Of course, everybody felt that it was in the public interest, and they were very patriotic, so they allowed the pipeline to go on their property without arguing with it. In 1993 was the year that they wanted to convert one of the pipes on my property. And when I signed the agreement, the land agent came to my land while I was planting corn, and they wanted me to sign the agreement, and I signed it without reading it because as my father and all of us knew, we couldn't stop the pipeline. And I signed it without fully understanding it. Later on, a neighbor came down to me and said, "Do you understand what you signed, Dave?" And I said, "No, let's go through it and read it." And after reading it, we realized that I gave them power of attorney over my whole farm, and that they had lied to me about what they wanted to do with the pipeline. They were going to be able to ship anything they wanted through it. So then all of us got together, the landowners. Some landowners drove the pipeline and talked to landowners along the pipeline, and we all came together to form an organization. We raised $200,000 to $300,000 and hired legal counsel to take part in the hearing process. By working together, we were able to prove that the pipeline application was unsafe, and actually we had the National Energy Board turn down the application. So by working together, we were able to share our knowledge and our resources, and we're able to stop that project. And that was the first energy landowner organization formed in Canada. It was called the Ontario Pipeline Landowners Association. Other landowners saw what we were able to do by working together. So on other projects, pipeline projects and gas storage projects, landowners learned to work together in a group, and were able to negotiate better compensation. After a number of years, by the year 2000, we had watched what we were able to do and realized that we were able to negotiate better deals, but we weren't able to change the legislation that took our land through expropriation. So then we realized that we needed a national organization, because at that time we were only a pipeline organization, and when you look at a map of Canada, the majority of the pipelines begin in northern BC, and then they cover Alberta, and then spread out across Canada, with only a few going through Ontario onto Montreal. So we realized we needed a national organization. So there was one association in Manitoba and 5 associations in Ontario, and I'm the founding chair of CAEPLA. We founded it and organized it, and then shortly thereafter we initiated some things to get national attention. Shortly thereafter, we did everything out of our back pockets. We had no funding, so we initiated a class action lawsuit against the pipeline companies, because they created, the National Energy Board created regulations that took more of our land away from us and restricted what we could do over the pipelines. We wanted compensation for another 200 feet of land that they restricted, called the control zone, and also the fact that they said we couldn't farm over the pipes without permission in the future. It took us 6 years to get to a certificate hearing, which is a preliminary hearing for a class action lawsuit. Once we never did get in court. It cost us, I raised $1 million to do this. And what the judges said was that we had no rights and no remedy outside the National Energy Board Act to go to court. So basically we were told that the National Energy Board Act prevented us from going to court in this case. Shortly thereafter, I climbed in my pickup truck and drove across Canada and followed pipelines across Canada to get, because I was so angry that we could not go to court, I drove across Canada and organized landowners right across to British Columbia. Since then, we've organized many landowner organizations on pipelines across Canada and negotiated easement agreements and compensation for them, and we also do the same on power lines in Alberta, and I'm working on one in Manitoba now. CAEPLA now, so what CAEPLA does, we're an advocacy group. We work on behalf of landowners that have linear energy projects, and we also do business, help people negotiate business agreements with pipeline companies. From an advocacy side, we have 2 websites. One, this website is our homepage website. It's more static. This one here we support. This website, and it's more of a daily news website and has many blogs on it that explains where CAEPLA comes from. So some of the goals of CAEPLA at this point in time, after being at this so long, I have come to the point where we do not trust the National Energy Board, the regulator, and we try to prevent expropriation. We view expropriation as strictly a transfer of wealth from rural landowners, rural farmers, ranchers, woodlot owners, and acreage owners to the owners of shares of pipeline companies. CAEPLA is also pro-oil, we're pro-development, but also pro-property rights and pro-choice. That means we want landowners to have the right to say no to a bad pipeline agreement. One of our taglines is that landowners want in, we want to be partners in the energy industry. But we also want to assert our right and our responsibility to steward the land. And the only way to do that is through ironclad contracts with the discipline of insurance and the use of the court of law to protect our property, because right now we can't protect our property. Back in the 1950s, the National Energy Board was created to protect, it was created as a blanket to protect bad decisions by government and pipeline companies. And it was also created to protect politicians and pipeline companies from the public and from landowners. And they've become very good at it because we all trust them and we trust the government that they're looking after us, when the reality is that we're being left with all the risks and liabilities of pipeline companies ultimately. When we started CAEPLA, we actually trusted that the NEB was there as advocates for landowners. But we have learned over the years by dealing with the NEB in many negotiations, attending many hearings, taking part in NEB processes, that all they do is compromise our rights as landowners. They make it very difficult for us to take part in their process. They say it's easy, but it's not. It's very costly. And then when we do take part in their hearing process, they ignore our evidence. Between the National Energy Board makes us think that the process is fair, and the pipeline companies set up barriers to us taking part in the process also. So really we have 2 things against us when we try to protect our land. The National Energy Board likes to say that they're regulating pipelines and making them safe. The only way we can have safe pipelines is for us to negotiate a contract to protect our farms. The National Energy Board will tell you, the pipeline companies will say they're going to deal with you under the National Energy Board Act. I keep going. But the National Energy Board will tell you that they have nothing to do with the easement agreement that you sign with the company and nothing to do with compensation. The important thing to remember, though, is that with expropriation or right of entry, they have everything to do with everything. Because in a private country, they say that the deal that we make with the pipeline company is a private contractual agreement. Well, the fact that the pipeline company has right of entry in their back pocket means that it's not a private contractual agreement, because it's not a level playing field. There's no willing buyer and willing seller. And then they say they have nothing to do with compensation either, that's an agreement that you negotiate with the company, but that's anything but the truth. Because again, with expropriation there, you do not negotiate fair compensation. They'll tell you under the Act that you have the right to go to arbitration. In 1975, arbitration was before an independent county court judge. We had a couple of landowners who took part in a hearing then, and the judge awarded them 10 times the compensation to mitigate their property after their soil was damaged by the pipeline. A short time after that, the National Energy Board, or Natural Resources Canada, changed arbitration from an independent judge to a panel, the Natural Resources Arbitration Secretariat, where the Minister of Natural Resources now appoints the arbitration committee. And that process is very lengthy and can take up to 2 years. And if one of those people get a job at the end of the hearing, you have to start over again. So the only way to resolve what we're doing is by working together. We found that in 1993. We found it every business agreement we've made across Canada, in BC, Alberta, Saskatchewan, Manitoba, Ontario, and New Brunswick. Your farms have the potential to become abandoned gas stations. Under the National Energy Board Act, abandonment, they can approve abandonment in place of pipelines. And if pipelines are not removed, historical contamination will not be found. The reason that is because you're signing an easement agreement, and under the National Energy Board Act, it states that your name stays on title. And if your name is on title, you are ultimately responsible for that pipeline, because if the company becomes insolvent or sells to a company that is not in the same financial condition that they are, ultimately your name's on title, the same as an abandoned gas station. The most important thing that you have to do is negotiate a good easement agreement to protect you from the risks and liabilities that these pipelines are transferring to you, your property, and your families. And it's also important to understand, that's why we would like to negotiate a lease agreement, but under the regulations that are there right now, we can't. A lease agreement would fall under tenant law and hold the company responsible for their facilities, and an annual fee renegotiated every 5 years would address the issue of maintaining the value of your property. One of the other problems with the easement agreement is that the National Energy Board, any regulations that they pass, supersede any covenant or overrule any covenant in that easement agreement. The National Energy Board continues to create regulations that transfer risk and liabilities to us. In 1990, they created Section 112 of the Act, which put restrictions on 200 more feet of our land, 100 feet on each side, 30 meters on each side of the easement, and also created restrictions that does not allow us to cross the pipeline without permission. In 1985, there were 7 regulations saying that pipeline companies had to take their pipe out of the ground upon abandonment, and that we should they should be collecting a fund to cover the cost of that. But then in the discussion at the time, they said as long as there are regulations stating that pipelines have to come out of the ground, pipeline companies will ask for funds to remove that pipe. The National Energy Board did away with those 7 regulations and created one that said that pipeline companies could apply to abandon a pipe, and the National Energy Board could approve abandonment in place. So that transferred all the risks for abandonment to us, because once the National Energy Board approves abandonment in place, they no longer have jurisdiction over the pipeline. The National Energy Board did away with those 7 regulations and created one that said that pipeline companies could apply to abandon a pipe and the National Energy Board could approve abandonment in place. So that transferred all the risks for abandonment to us, because once the National Energy Board approves abandonment in place, they no longer have jurisdiction over the pipeline. The National Energy Board is not our friends. The National Energy Board acts at the behest of pipeline companies to transfer pipeline company risks to us. One pipeline vice president said to me the other day in a call, he said he had no responsibility to landowners, his only responsibility is to his shareholders' profits. They're not your friends.
Qu'est-ce qui se passe si un agriculteur refuse de signer? Et pour ceux qui ont déjà signé, qu'arrive-t-il s'ils refusent les nouvelles normes qu'ils n'ont pas signées?
If the National Energy Board creates new rules, they supersede anything in any agreement you've got, and you have to accept them. You can't, there's nothing you can do about that. If a farmer refuses to sign, the National Energy Board will give the company, whether it's TransCanada or Enbridge, right of entry to come in and construct the pipeline, and they will hold the farmer at bay while they do that, and then the farmer will be left to negotiate after the fact. The pipeline company will serve as a National Energy Board Section 87 notice to the farmer, and in that notice will be the compensation, the easement agreement, and then the regulatory process if you don't want the pipeline and if you don't feel the compensation is fair. The thing that's important here is that that document has National Energy Board Section 87 notice on the top, so it looks like a government document. But actually what it is it's the pipeline company's offer to you. The interesting part of that is the regulatory process. There's 3 hearing processes, or 3 processes a landowner can take part in. One is the certificate hearing. The next one is the detailed route hearing, and the next one is arbitration. The Section 87 notice doesn't even mention the certificate hearing, which is the most important hearing for landowners to take part in to protect themselves. The certificate hearing is before the pipeline is approved. The detailed route hearing is after the pipeline is approved, and arbitration is after the pipeline is built. And if you're going to take part in the certificate hearing, you need to be thinking about that now on the Energy East project.
Si 200, 1000 propriétaires ou agriculteurs refusent de signer, qu'arrive-t-il?
That's what CAEPLA does. That's how we level the playing field, by getting landowners to come together. And then it's very difficult, it's bad public relations to expropriate a lot of people. The process was created to divide and conquer. And it works very well, because landowners work against each other by thinking they're smarter than their neighbor and they can negotiate a better deal. And then even if you do come together and work together, the pipeline company will undermine you by offering more money, etc.
First of all, I want to oblige the company when they put a new, that's TransCanada pipelines, when they put a new pipe in, that they cover at least 5 foot over it, for the newer machines get heavier and heavier. So on a foot, for now they took 3 or 4 foot on it.
That's a very good point. We have asked that pipelines be buried and tried to negotiate that they be buried 5 feet. Common practice today is 1.1 to 1.2 meters, but the pipeline company will tell you that they only have to bury it to Canadian Safety Association standards, which is 2 feet. The National Energy Board in 1990 created Section 112 of the Act, which restricts what we can do over the pipelines. And the reason they did that is because many pipelines are too shallow, and because they're corroding and becoming unsafe. So that's why the board took away our right to normal farm practices over the pipe. It is easier for the National Energy Board to make it costly for us, rather than force the pipeline companies to upgrade their facilities and bury the pipelines deeper.
Vous avez manqué de traduire que normal farm practices sont interdits à partir de 1990. Ça veut dire tu ne peux pas passer avec un tracteur charrue, ni batteuse, ni autre machinerie. Si le pipe est en travers du champ, ça va être impossible de travailler. Hein.
Avec la profondeur du pipeline, à la profondeur qu'ils veulent le placer, il se passe quoi avec nos terres qui sont déjà drainées, que les drains arrivent complètement à la hauteur des pipelines sur le sens inverse?
I come from southwestern Ontario where we did a lot of tile drainage, and we want pipelines buried 5 to 6 feet deep so we can tile over top. But what we've had to do is put header tile in on each side of the pipe, which is wrong. They should not interfere with our drainage. It should be their cost to replace them and put them back in the way you want them, but you know, they'll decide what is right themselves. Those are some of the things that if you work together with your neighbors, we negotiate.
Qu'est-ce qui arrive si, par exemple, sur mon terrain, il faut qu'il creuse pour réparer des anomalies? Est-ce que c'est l'Office de l'énergie qui règle ça ou si... Comment on peut avoir un dédommagement pour les problèmes causés par leur action pour réparer?
You're left to deal with the company, and in most cases they'll just use their easement agreement, whether it's 40 years old or 30 years old. There's nobody there to help you. It's up to you to negotiate with the company. What CAEPLA's done, we have associations in Canada that actually have negotiated standard integrity dig agreements so that it's all spelled out ahead of time. We have actually, CAEPLA has asked the National Energy Board to accept some of these agreements that we have negotiated as standard practice, but they won't do that. So you're left, the National Energy Board leaves you on your own.
We signed a contract in 1977 with for Enbridge. Does that contract stand as it was? With the inversion of the new project with Enbridge to reverse the flow, are we subject to the new laws? Does this farmer have, can he rely on the contract he signed, or is he subject to the new rules and regulations even if though they didn't exist when he signed?
He's subject to the contract he signed, plus any new regulations that were created that he had no input on. If they want to take more land, a bigger easement, then he needs to negotiate a new contract.
The UPA is negotiating contracts in block for all the farmers. What do you think of those arrangements?
I want to avoid getting involved in politics, but I would suggest that you are better forming your own group across Quebec, and that you hire professional negotiators with expert legal counsel that have experience in doing this and have done it across Canada.
There is in Quebec a law that protects farmland against any other use. And do they have to have a say on any project from any companies that go through farmlands?
Oui, Jean-Claude Charette, je suis agriculteur, je suis touché par les servitudes. Je dois dire que le projet, le tracé, doit passer au BAP avant, qui est un organisme, le BAP s'appelle le Bureau des audiences publiques en environnement. Alors, TransCanada doit déposer son projet à l'automne vis-à-vis de BAP. Le BAP va dire oui à certains endroits, non à d'autres endroits. Et comment le faire dans certains endroits? Ça, je suis pas mal sûr. Après ça, vous vous en allez à la CPTAQ. La question qu'il faut se poser, et selon moi, est-ce qu'il est trop tard quand on est rendu au BAP et qu'on est touché par le tracé? Alors, vous êtes mieux de vous occuper de vos affaires avant. Ça, c'est très important.
Even if CPTAQ, our board, farmland protection, doesn't approve of the project, it's still a federal project, therefore they can go on.
Yes. In Alberta, 3-4 years ago, the National Energy Board took jurisdiction of 25,000 kilometers of pipeline, and that took away many rights that farmers had from provincial jurisdiction. They lost rights.
On va parler avec M. Lemieux plusieurs fois, qui est celui qui s'occupe de ça. La seule force qu'on a par rapport à CPTAQ, c'est faire changer des sites de pompage, les envoyer dans une place de moindre impact. Mais à CPTAQ, c'est pas un frein à la décision du passage d'un pipeline. C'est pas ça. Plus le pape, les petites grenouilles dans les forêts, les oiseaux passent avant bien souvent que l'agriculture. C'est bien plate à se faire, c'est ça.
I want to make something perfectly clear here as I listen. CAEPLA does not trust regulators. We don't trust them to protect farmland and farmers. We believe in negotiating business agreements that protect your property. The intention of governments and regulators and pipeline companies is corporate rent control. It's rent control for pipeline monopolies. It is only by working together that you can protect your farm businesses, you can protect yourself from risk liabilities, you can make sure that the pipe is thick enough to allow you to cultivate over it, to address abandonment issues, to make sure it's deep enough. It is only you that can do it. Don't trust anybody else to do it. And it's only by the respect of property rights that this will happen, and it's only by our own hard work that we'll be able to protect ourselves. And again, I repeat, it's only by working together.
Tantôt, on a mentionné qu'est-ce qui arrive pour coupe vos drains. D'abord, vous savez que quand on creuse, la compagnie creuse, c'est un chantier, vous n'avez pas le droit de mettre les pieds là. Il y a une personne qui est nommée par l'UPA et c'est avec elle que vous devez travailler. Dans Sainte-Clette, ils ont passé le 5 ans passés, le contracteur a fait défaut, il a fait faillite, le tranché s'est empli d'eau durant l'été parce qu'il pleuvait énormément. Les producteurs ont eu de méchants problèmes, je peux vous dire ça, à faire recollecter les drains. Et après, évidemment, on voulait mettre le sol égal parce qu'il y a des gens qui ont dit, ben, on a des, quand on boit de soya, on a des tables de 25, 30, 40 pieds. Ce qu'ils ont fait, ils ont posé des boules sur la terre, eux autres, qui étaient excavées. C'est venu plat. Alors, c'est le suivi qu'il faut être très important là-dessus.
In response to that, when we negotiate agreements, we have in there, we address liability issues, we address risk issues, we address construction issues. We negotiate all those issues in a legal contract.
In this case, the pipeline wants to, the TransCanada wants to put the pipeline on a corner of his farm, which he has reserved for building himself a home if one day he sells the farm. So what he wants to know is if he can ask the pipeline company for extra compensation, which would enable him to build a home elsewhere if they take that land.
You can attempt that, but I would suggest that you get it appraised right now. You know, you need to have something documented that shows that that's what you're going to do with it, because I agree with you, that should be the case. If you had property rights and they didn't have the right to take it, then you would negotiate that. But in this case, you probably can't.
Si supposons, ça se met à couler sur ma terre, puis le drain, il arrive un déversement. Est-ce que le cultivateur va être tenu responsable?
This is complicated. You cannot trust the pipeline company and the National Energy Board to clean it up properly. There is a spill in Ontario right now where the National Energy Board and the pipeline company have not enforced the cleanup to provincial standards. If that is never cleaned up to provincial standards and the National Energy Board approves abandonment in place, the NEB no longer has jurisdiction and the landowner will fall to provincial safety and environmental regulations. One last thing, pipelines have pinhole leaks in the bottom of them. Very fine leaks, and they don't show up for many years, and if the pipeline is not removed upon abandonment, those leaks cannot be found. So if they show up later after abandonment, they're yours. And that is why we want pipelines removed at abandonment so that we can find any historical contamination because there's no other way to find it.
Monsieur ici veut savoir quelle est la durée de vie d'un pipeline.
I have a document from a court case in 1975 where the president of Interprovincial Pipelines said that pipelines were designed for 30 years, but now they say that pipelines will last forever.
We bought some land that was for sale when they built the Mirabel airport, and it's land that was expropriated. We bought it with the pipeline on it. Does that mean that we bought the responsibilities that you're talking about?
Yes. We talked about how long pipelines would last. Line 9 is the same age as Line 3 and Line 6 in Kalamazoo. Those pipelines were built in the 60s and 70s, and engineering practice at that time coated pipelines with a polyethylene tape. Polyethylene tape causes pipelines to prematurely corrode because it doesn't allow cathodic protection. Right now, Enbridge is replacing Line 6 because it ruptured in Kalamazoo, and they're in the process of replacing Line 3. Why are they not replacing Line 9? Line 9 should not be reversed. It should be replaced with a new pipeline.
J'ai vu sur le site de l'Office de l'énergie qu'il pouvait y avoir des fonds pour les propriétaires touchés par un tracé du genre. Est-ce que c'est vrai? Combien il peut y avoir? Et qu'est-ce qu'on peut faire avec ça?
There will be an intervenor fund for landowners taking part in the certificate hearing. Since the company has not applied yet, I don't know if it's been created, and you'll have to apply for it and you'll get a portion of it. And we're trying to organize landowners in Alberta, New Brunswick, and possibly Quebec. And we could pool that funding to address all of our issues. If the National Energy Board says they're going to have $200,000 available, it depends on how many people apply. We might get $60,000 or $70,000. What we really need is $500,000. Or what we need is many landowners signing together to level the playing field. Outside of money, the most effective thing you can do is to have 70 or 80% of the landowners together. It's the only way that we're going to get the government, regulators, and pipeline companies to listen to us. That's the only way. The Energy East project is a new pipeline from Hardisty to Burstall, Saskatchewan, and then new pipeline from Cornwall to New Brunswick, to St. John. In Ontario, there's only a very little new pipeline. Well, yeah, and we're here. We'll organize in Ontario too if somebody gets them organized. We have a pipeline group in Ontario on the Enbridge pipeline, Line 9 from Sarnia to Kitchener-Waterloo, and we're trying to get more. We work on one pipeline at a time.
Moi, j'aimerais savoir, est-ce que si on mobilise tous les agriculteurs ou les propriétaires fonciers au Québec, est-ce qu'on peut empêcher TransCanada de passer au Québec? Un peu comme la Colombie-Britannique, je pense qu'ils ont fait quelque chose de ça pour l'empêcher.
British Columbia hasn't stopped anything yet. That's not done. If you work to stop the pipeline, you'll end up with the pipeline and none of your issues addressed.
Can you talk about at least one example that where you've succeeded somewhere else in Canada to have a pipeline replaced when it wasn't the initial plan of either the oil company or the federal government?
None. We've never been able to force a pipeline company to replace anything. We've negotiated new pipeline agreements, but that is the question, isn't it?
Yeah.
No, we're not able to force. With Line 9, the National Energy Board has set up a process so that all Enbridge has to do is repair the bad spots on Line 9, and they will approve the reversal of Line 9. We have taken part in hearings to try to say that Line 9 is not safe, and we're ignored. The thing is that the only way we will get change is by a movement of people. I would never say that we could never do it. If enough people came together, like if we had 100% of landowners come together, we might be able to force anything, but that has never happened. There has never been a voice for pipeline landowners across Canada until CAEPLA. And I still have a hard time getting landowners to protect themselves and work with us. As Canadians, we trust the government, we trust the natural regulators, we trust everybody to do things for us. If we do it ourselves, we can make change. CAEPLA has done many things that we never thought we could do. Never say you can't.
Concernant les servitudes, le terrain qui sert aux servitudes, existe-t-il une jurisprudence, un exemple, où on a évalué le terrain à des périodes de 5 ans, de 10 ans, pour avoir une compensation pour l'agriculteur?
To answer this question, when they build a pipeline on your property, they're going to pay you agricultural rates for your land, or possibly, if it has been deemed development land, development rates. But the fact is when they build a pipeline on your property, it's for industrial use, if you go with that. It's like having land next to a city where they're going to develop housing or industrial development. That land should be priced at an industrial rate. It's a transportation system through your farm. We have negotiated a linear payment for pipelines to represent that industrial rate over and above agricultural rates. We have negotiated $35 a linear meter. This agreement was negotiated in 2007 on the Enbridge Southern Lights and Alberta Clipper pipeline in Saskatchewan and Manitoba, a Dilbit pipeline. That's over and above what they pay for damages, at the acreage fee, temporary workspace. The one thing though I want to say is we don't really like a lump sum payment. What we'd like to negotiate is an annual fee, renegotiated every 5 years, tied to inflation and land value.
Bon, TransCanada a fourni un tracé à Saint-Anne-des-Plaines, puis les cultivateurs n'étaient pas tout à fait satisfaits du tracé choisi. Ils en ont suggéré un autre. Est-ce que, dans votre expérience, TransCanada a déjà écouté des cultivateurs et dire « Je vais prendre votre tracé » ou bien c'est mon tracé qui mène et fermez votre boîte?
How many landowners do they have working together?
They got 50 landowners.
They might move it. With that many landowners working together, they might. But then you're forcing it on your neighbor's land. No? No? Oh, okay. Well, that makes sense. I understand. I want to go back here for 1 second. Those landowners, that $35 fee over and above the land value fee was 10 to 15 times what Enbridge intended to pay them.
On sait que TransCanada possède des éoliennes dans le Bas-Saint-Laurent et ils ont payé les producteurs pour implanter les éoliennes et les producteurs sont payés et ont des redevances par le nombre de kilowatts qu'ils produisent à l'année. Est-ce qu'on doit avoir une redevance pour le nombre de barils de pétrole qui passent quotidiennement ou annuellement?
I agree with him 100%. That's why I do what I do, and that's why the whole system is wrong. They should not have the right to expropriate us. I know that there are cases on First Nations or Aboriginal land where they are paying that kind of annual fee.
Est-ce que des membres de votre association ont déjà vu des fuites qui sortent du sol ou une expertise un petit peu? Parce que moi, j'ai quelque chose qui sort du sol chez moi au-dessus de la pipeline. Puis je me demandais si en Ontario, vous aviez déjà vu ce genre de fuite-là. Parce que là, ils disent que c'est de la swamp, que je cultive sur une swamp, puis c'est de l'eau de swamp qui sort. Alors moi je comprends pas. Je suis toute seule me débattre, puis j'aimerais ça avoir une expertise peut-être en Ontario, s'il y en a eu qui ont déjà eu ce même genre de problème-là.
Yes, they're telling a landowner in Ontario right now the very same thing, that it's swamp. When Enbridge or a company comes on the land to take a soil sample, you should demand that a sample be sent to an independent tester also that you're paying to have it inspected so that you know that it's safe.
She did that. She sent it to Environment Quebec and they told her it was swamp juice.
You know, I understand how this gentleman feels, This is a swindle, okay? It's nothing but. The National Energy Board was created to swindle the public and swindle us into allowing unsafe pipelines on our land. Expropriation in most cases, like for roads, title is transferred to the people that expropriate. In this case, title stays with you, and then all the risks and liabilities do too. As long as pipeline companies are making money, they will protect you from the risks. The moment it's not profitable anymore, it will become the landowners.
C'est-tu le même principe que pour l'Hydro-Québec? Ils nous en payent, admettons, 75%, puis après ça, nous devons payer des taxes pour tout.
The problem with this whole thing is that landowners bear all the risks and responsibility, but everybody else gets the advantage. Local governments get annual fees and taxes. They can raise it. Provincial governments get annual fees in the form of taxes, and federal government does too. And yet we bear the risks and liabilities, and we don't get an annual fee. It is a swindle.
I'm not right on the line, but it's an abomination. It's an abomination. We have to get together and do something about it. It's terrible. We can't tolerate this theft anymore. Yeah, let's do it.
Je me sens encore plus fort. Parce que dans une négociation, il y a toujours un rapport de force qu'il faut que vous mettiez en place. Que ce soit avec votre femme, que ce soit avec votre n'importe qui, il y a toujours un rapport de force pour vous déposer ou bien vous préparer. Si je prends tes services, est-ce que je triple ma compensation?
I make no promises because everything is against us. We do what we can. The higher the percentage of landowners we get, the better the negotiation goes. If we only get a handful, it's better than, 2 is better than 1, 5 is better than 2, 10's better than that. But, you know, the higher the percentage, the better we can do.
La protection tout autour de ça, éventuellement à long terme.
And I want to address that. This agreement is, see how thick it is? And there's many addendums to that. The easement agreement that the pipeline company will give you will probably be 3 to 4 pages. This is 20-some pages.
Moi, par rapport à ce que j'ai entendu, je suis extrêmement d'accord qu'il va falloir se mettre plusieurs ensemble. Dans la négociation qu'il y a eu à Sainte-Anne-des-Plaines, à date, on n'a pas eu encore de résultats. C'est certain que lorsque tu dis non, on ne veut pas chez nous, c'est tout le temps la meilleure des façons. Si on est capable d'offrir des solutions, des façons de faire, des façons de passer, pouvoir changer ça. Puis moi, sur la question de la compensation à long terme, je ne peux pas croire qu'on va transporter de l'énergie pour tout le monde, pour la société au complet. Puis nos enfants et nos petits-enfants vont être prêts avec cette problématique-là sans avoir de compensation. Parce que là, présentement, on peut se retrouver à avoir un chèque. Oui, c'est bien beau, à 2,5 fois la valeur de la ferme ou du territoire utilisé. C'est pas ça. C'est à long terme. Je ne peux pas voir une vie vers ça si on ne peut pas avoir une certaine forme de redevance à long terme pour nos enfants, petits-enfants, tant que c'est utilisé. Il n'y a pas d'autre moyen plus, ils disent logique, de transporter en plus cette énergie-là, que ce soit pour de l'électricité ou pour n'importe quoi. On est pris présentement, il faut faire vraiment un blocus au niveau du Québec, pas pour empêcher le développement. Parce que si on prend le chemin, je crois, d'empêcher, tantôt il nous a dit qu'il n'y a pas beaucoup de chances que ça marche. Et de l'autre bord, on passe tout le temps pour les personnes qui sont contre le développement. Alors je pense qu'il faut prendre le chemin de trouver des solutions, des idées, et d'aller le plus possible, d'être en force ensemble, parce qu'en plus, si on fait que s'opposer, on va perdre des joueurs. Il y en a qui sont bien prêts à travailler avec nous autres, mais si on prend le chemin du empêcher un projet, on va en perdre, puis là, c'est là qu'ils vont pouvoir diviser pour mieux régner.
Okay, I think I need to explain that when we negotiate an agreement, it's you folks that negotiate it. Okay? Can you put up the authorization? When we form a group, you'll have a committee, a negotiating committee will be appointed across from the group. This is an example of the authorization and direction that we created for New Brunswick. The negotiating committee goes with me and the lawyer getting Enbridge to the table will be difficult, but once we do, or TransCanada. Once we do get to the table, then the committee myself, and our legal counsel will be there to negotiate. And we will negotiate the best agreement we can based on the number of people, the percentage of people that we have. And so this last portion here, we'll suggest that we've gotten as far as we can get without losing everything, and we will bring that agreement back to ratification meetings. It will not be up to me to decide if the deal is done. It will be left up to you to decide if the deal is done. And it comes back to a ratification meeting for a democratic vote. In this case, in Manitoba and Saskatchewan, we had 8 ratification meetings across the 2 provinces. So it is a group that makes the decision if we have an agreement or not. It's not me, and it's not the committee that has the final say. In the many negotiations that we've had, not one has been rejected, but there's always the first time. This is a very slow and difficult process that takes a great deal of patience, and then to get it resolved takes a lot of patience too, because everything works against us. The company will try not to deal with us. They'll try to deal with individual landowners to undermine us, and they'll continue to try to split landowners apart to undermine the process so that they can get the easement agreement they want. And the most important thing is this agreement more than anything else. But I do agree, there should be, we say that landowners want to be part of the industry. We want in, you should be sharing in the profits. I agree with that, but number one, you need a contract that protects your land into the future and protects the next generations. That's the first thing you need, because it doesn't matter how much money they give you, it won't address these issues. And addressing the easement agreement is, you know, if we want the public on side, respecting our stewardship responsibilities and getting this addressed will keep the public on side and help them understand our issues better. And if we can get a movement across Canada, thousands of landowners with pipelines and power corridors across Canada working together, we will get that annual fee in a lease agreement in the future. We will get it if we work together. I think to explain what a swindle this is, Pat Daniels, the CEO and president of Enbridge Pipelines, after Enbridge polluted 60 miles of the Kalamazoo River, he didn't go to jail for doing that. He got a retirement package of millions of dollars and took his retirement and left. He should have been put in jail, in my opinion.
He's been told by the companies that if they want to work together, a group of landowners, that the company will pay for an expert to help advise them. What he wants to know is, can they hire you? And if not, how does this get paid?
The first major agreement we made in Western Canada, we did at our own cost to get credibility. When we were done, and the process had followed what I said it would, it took 2 years to get a settlement. And after it was ratified, I asked the landowners if they would give us a percentage of what they got to cover our costs and to support CAEPLA. 90% of the landowners agreed, and 90% of those landowners paid us a percentage of what they got. If you were to hire a lawyer or somebody else to do this, you would have to sign a retainer with them and put up a great deal of money. So now what we do, after we settled that agreement, some landowners took me into Alberta to negotiate the Keystone and Keystone XL pipeline in Canada. We had them sign an agreement to pay us 6% if we got a settlement agreement. So now in every negotiation we do, landowners agree to pay us 6% if we get a ratified agreement. And that money goes to CAEPLA for the nonprofit organization and our advocacy work. And if we have enough people and we have a strong group, we're able to negotiate recently with a number of companies that the companies pay the 6% over and above. The negotiation process, we use legal counsel. We make the company pay all legal fees and all negotiation costs. We don't go to the table until those costs, we create a budget and those costs are put in trust with our lawyer up front. And we don't go to the table until that money's in the account, because I do not trust pipeline companies to pay our fees. They try to back out of it afterwards. I've had a landowner group that got left owing $1 million and the company only paid 50 cents on the dollar. In most cases, they say they don't have to do that, but we force them to do it. And I only use one law firm, the same lawyer that I've used since 1993, who understands the National Energy Board Act. I won't use anybody else.
Il y a un cas dans le nord de la Colombie-Britannique où il y a une compagnie qui a acheté des contrats, puis quand ça a été le moment de changer le pipeline, ils ont dit qu'il n'y avait pas assez d'argent pour le faire.
And so these companies get to sell this easement agreement for huge profits, and you share in none of it. You only bear the risks.
But he wants to know if they can force TransCanada to go on Enbridge's existing servitude, so existing easement.
If you get enough landowners together, I don't know what you can't do.
I got a letter from Enbridge a couple of years ago that we are not allowed to pass heavier than 10 tons. Today, any combine loaded is 20 tons. So if they cross across a field, there you go.
And I agree, and that's why CAEPLA exists, because if we don't have an organization fighting for this. When the Alliance Pipeline was built through Canada into the US through Illinois, landowners got together and got the Illinois government to force them, because from yelling and screaming, got the pipeline buried 5 feet. In Canada, it was only buried 3 feet deep, because landowners did not organize. It wasn't because of the government, it was because the landowners created enough risk.
N'oubliez pas que le gouvernement du Québec, la semaine passée, il a dit oui, d'accord avec ça, au projet de Enbridge. Il y a des raisons à ça. Alors, on s'entend pour dire qu'il faut que le projet passe. Et il va dire oui aussi au projet de TransCanada. Vous savez que s'il y a des débuts de fuite, les premiers répondants sont vos municipalités qui ont déjà reçu de l'argent.
Un chèque de 10 000.
Allez voir votre maire, là, puis demandez donc quelle sorte d'enveloppe il a reçu de Enbridge. Et ensuite, ils étaient les premiers informés avant que vous soyez informés, vous autres. Chez nous, ça a été le cas, en tout cas. Ça, j'ai trouvé ça un peu renversant. Vraiment renversant. Et pourquoi quand on veut britannique, ça marche moins? Parce que le gouvernement a dit non pour le moment. Alors, Québec a dit oui, parce que vous savez que plus ils sortent du pétrole de l'Alberta, plus par l'équation entre les provinces, plus ils en reçoivent. Les provinces pauvres. C'est le système actuellement.
Okay, I just want to finish by saying that whether you join CAEPLA or not, I hope that you protect your property and your stewardship responsibilities, and I hope that you understand that you have to work together to get this done. Whether you work with CAEPLA or not, please protect your land and work together and protect your property rights. If you don't join CAEPLA, form an association and get as many members as possible.